Hi, I'm Shannon Miller with the Miller Elder Law Firm, and I'm here with Courtney Lipolis and Jenna Fasulo Lapierre. We're here to talk today about some pending federal legislation that would reduce estate taxes. Jenna, can you tell us a little bit about the Bernie Sanders bill?
Absolutely. So this is a very recent piece of legislation that is being proposed. On March 24th of this year, 2021, Senator Bernie Sanders introduced a bill into the US Senate to impose higher taxes on wealth. The bill was called the 99.5% Act. So the nuts and bolts of the act, without going into all of the specific details, is basically that the current estate tax exemption is $11.7 million per individual, $23,400,000 for married couples. Sorry, I'm going over my words here, but in essence, that number now in the proposed bill goes down to $3.5 million with a combined estate tax exemption for $7 million for married couples. The breakdown of the taxable rates go from estates less than $10 million, that's a 45% tax rate. And then it goes all the way up to estates worth more than $1 billion to a 65% tax rate. The second kind of bucket of notable information contained within this legislation is the changes in the gift tax. So currently the lifetime gift tax exemption amount, so currently in 2021, is 11.7 million. The annual gift tax exemption is 15,000. Under the proposed bill, the new legislation, the lifetime gift tax exclusion amounts would be reduced to only $1 million, $2 million for married couples, and then the annual exclusion amount would be reduced to $10,000 per donee. At this point, the biggest thing we really need to look at is the lifetime gift amount to have is really only the $1 million exclusion for someone during their entire lifetime. That's a very big drop from the 11.7 that we're currently having.
Now, this legislation hasn't passed yet.
That's correct.
Right? So this is what's been proposed. But with regard to that second part, right now, we know that we have clients who are giving away $15,000 a year, and that $15,000 or under a year then just goes and applies to their $11.7 million lifetime coupon from the IRS. We always talk about the coupon that you get from the IRS. And, if people need more information about what we're talking about there, they should go look at our YouTube video on trust-based planning. But the idea of that $15,000 then applying anything over that amount would apply to your lifetime cap, right? Anything under that amount, you don't have to even report it to the IRS.
Right.
Anything over that 15,000 would have to be reported to the IRS using a 709 gift tax return. So that is a significant change. And what we know now is that anything over that $10,000 amount gets reported to the IRS, and then it's going to apply against a second type of credit, which is like this $1 million lifetime gift tax credit. So that is a significant change. And I know there's some other changes in the legislation that we're really not going to talk about today, but those are the basics. So Courtney, you are our estate tax paralegal guru extraordinaire.
I am the estate tax paralegal, yes.
And you love estate tax stuff.
I do. I love helping clients preserve their wealth for further generations and just preserve it from the IRS.
You're also the funding queen, right?
I am the funding coordinator, yes.
So what does that mean exactly? When we talk about funding, what does that mean?
So I help, and after we draft a trust-based estate plan for our clients, I assist the clients with retitling their assets into their trust and also dividing those assets in between, if it's a married couple, between the husband and wife trust. So they can take advantage of estate equalization.
And so let's just talk hypotheticals. So let's say I'm in a married couple,
Mhm.
and my husband has life insurance. He and I share a homestead. Let's say the life insurance is $1 million on his life, and let's say I have $1 million on my life. And let's just say we have a homestead and we have retirement assets and some other assets, so that each of us has, let's say, $2 million worth of assets in
Right.
our names. And let's just say that I die and all of our assets are titled not in a trust, but instead are just titled like most married couples,
Mhm.
so that they pass to my husband when I die. So life insurance goes to him. He's the beneficiary on my IRA. I've named him on all my other stuff. And then he ends up with my $2 million that then joins his $2 million.
Yes, and unfortunately, what happens here, and I think a lot of people are under the misnomer that their whole entire goal is to avoid probate. So yes, that type of titling would avoid probate of the assets. However, it does not avoid estate tax on your assets. And in that case, the surviving spouse would assume all of the spouse's assets, and unfortunately, their estate would have a higher taxable estate value and unfortunately be taxed. The overage would be taxed at 45% in this case.
So if they had $4 million when husband died, if he had $4 million, that additional 500,000 over the 3.5, and again, we're talking if the Bernie Sanders bill became law, then they would owe 45% of $500,000. So that could be like $200,000 in estate tax.
That's right. Yes.
Okay. So how could they avoid that? What could that couple do to avoid that estate tax?
So what they could do is they could come to us and we could create an estate plan involving what we call A and B trust, husband-wife trust. So it would, the husband would have a trust and the wife would have her own trust. And we can make sure the assets of their estate are equally divided between the two trusts entitled in each trust. So that would avoid the estate tax that could be levied at the death of the surviving spouse.
Now, each of those spouses would still want to file a 706 estate tax.
That's correct. That's the most that is an important point that gets missed a lot. That yes, even if the assets were properly titled in each trust, at the death of the first spouse, there would still need to be a 706 estate tax return filed.
And the reason for that would be like, let's say if estate taxes went down again for the second spouse, or let's say that those assets of the second spouse grew during the time when first spouse dies and second spouse dies, then we might want to take advantage of that leftover part of the coupon, right?
That's correct, yes.
So if spouse A died, if I died with $2 million in assets, but my coupon from the IRS was $3.5 million,
Mm-hmm.
I'd want to file that estate tax return so that I could get credit for that additional 1.5 million that was left on my coupon and hand it off to my surviving spouse. We know that's called your disuya.
Yes.
And so you'd want to be able to take advantage of that by filing that 706 estate tax return.
That's correct.
So I don't want to get too in the weeds today. We just wanted to give that update, making sure that people know what the pending legislation is out there, and encouraging people, get your trust-based plan in place if you have concerns about estate taxes. I don't know, anything else, you guys, we want to tell our people out there?
Give us a call.
Thanks so much. I'm Shannon Miller with the Miller Elder Law Firm. Have a great day.